The next case today is State v. Fazio. Each party has 15 minutes to present their argument. Each time there is up to 5 minutes for rebuttal. Do you know how long you'd like to reserve?
3 minutes, Your Honor.
All right, very good.
Are you?
I will keep you time up here.
Great.
I will have to let you know you have about a minute left in your initial time. The 3 minutes for rebuttal, I probably not interrupt you with that.
Got it. Thank you.
The arguments are being recorded. So if you would, when you come to the podium, start your presentation, introduce yourself. Please stay behind the podium. Don't move, because of course if you move, we kind of lose you there, and also keep your voice up so you can be heard on the recording. If there is a cause in this case to refer to any victims or any children or minors, please make sure you refer to them by initials or some other term like the child or the victim. We have read your briefs and are ready to proceed whenever you are.
Thank you, Your Honor. My name is Louis Brube. I'm here on behalf of the defendant appellant, Brian Fazio. May it please the court. Brian Fazio was put in prison for life with only the possibility of parole. Parole represents such a small hope after someone's been put in prison for life. Nobody has a right to it. It's merely a matter of legislative and executive grace. An inmate can only hope for a chance someday to convince the parole board that they have been adequately punished and that their release would not endanger the public. So in a small class of cases like this one, the earliest possible parole hearing, though, is pushed years down the road, well beyond the time frame set by the General Assembly. And after a trial court decides to impose consecutive sentences on top of a life sentence, the question then becomes, is that necessary? It is not. It is unnecessary to accomplish anything. Statutory purposes of protecting the public and adequately punishing an offender that can justify consecutive sentences are already met through the parole system. And putting that process off until later is at best duplicative. This court should intercede to rein in the practice of stacking prison sentences when a person will be presumptively spending their life incarcerated, because all of the findings here must be made, and one of them goes to necessity. So I'd like to start with that. Let's talk about the meaning of the word necessity, because this court must assess whether the record supports the factual findings. The trial court wasn't supposed to, or wasn't required to make any particular kind of finding, right? There's no rule that the findings have to look like X, Y, Z. As long as the record demonstrates the findings were made, then this court turns to the facts supporting the findings. Are there any facts supporting the findings? 29-29-14C4 requires a finding that the consecutive sentences are necessary to punish the offender and to protect the public. And that word necessary, this court's review of those findings must be mediated by that word necessary. It's in the statute. It matters. It's there for a reason. It has to be given effect and force, just like every other word in the statute. So necessary, what does it mean? We've relied on Merriam-Webster Dictionary, the Ohio Supreme Court's favorite dictionary, calls it absolutely needed, in all caps, required. We also use dictionary.com, that's a pretty easily available one. Essential, indispensable, or requisite. We've also relied on instances in the past where this court and the Ohio Supreme Court have considered what the word necessary means in other contexts. It's not a word that is sparsely used in the revised code. It shows up in all kinds of provisions, all kinds of legal requirements that people have to follow. In the Chaudhry case, I liked how it was written. I know it's not published. We've cited several other 9th District decisions that are following the same analysis. That was in the context of a change to the spousal support statute, which went from, I think, reasonable and appropriate to necessary, or vice versa. I think the change was from necessary to reasonable and appropriate, opening up the court's discretion. And this court recognized in those cases, well, there's a difference between appropriate, reasonable, sufficient, adequate, and a word like necessary. So in those cases, since the word necessary had been taken out of the statute, the court no longer had to make a decision that they were strictly required, that like the order that was being issued was absolutely strictly required in order to achieve the purpose, right? Necessity goes to a purpose. That's what the definitions say, right? If a statute says necessity, the court has to be doing whatever it's doing to achieve some identified purpose. Here it's protecting the public, punishing the offender. The exact same considerations, the primary considerations that are taken up by the parole board. Now, we also relied on the Kearns case. It's a different context. That was in a civil matter. There was a restriction on a bequest in a will. It was a life estate, and it said that the widow could use the property as necessary. This court determined in Kearns that since the widow had adequate finances elsewhere. She didn't strictly need to sell the house in order to support herself, so it wasn't necessary to sell the house because there was some other thing that would achieve that same purpose for her. By analogy, it's the same thing. I mean, we're just here arguing that in a case where there is a life sentence and where the parole board will take up its work someday, but there's no need, there's no necessity to stack sentences, interminable sentences. We're talking about the difference between 30 to life, which would be the baseline that this court could amend the sentence to, this court vacated the sentence or just fixed the sentence itself. 30 to life plus some potential Reagan-Tokes time could apply, I think. I'm not really sure how that works. But the sentences here are substantially more than that. We're talking about 44 to life on the trial case, plus potential 5 years of Reagan-Tokes time. 48.5 years concurrent to the trial sentence in the plea cases, with the possibility of an additional 11.5 years of Reagan-Tokes time. Now, if this was all run concurrent, it would all sort of fall into that 30 to life term, which is a 25 to life plus the 5-year RVO spec. So, so what purpose? What purpose could it possibly serve to push off that time when the first parole hearing could come up? In order to prevent that parole hearing, that's the only thing that the consecutive sentences are actually doing. Because defendant Fazio is not getting out of prison presumptively. He's spending life in prison. So 44 years, 60 years, 48.5 years, it's fairly indeterminate, and I mean, the purpose of indeterminate sentencing is so that considerations like the necessity of protecting the public, like the necessity of punishing an offender adequately, can be assessed down the road. Once we can see what the punishment has done to a person, once we can see what kind of person they've become, whether they are actually a risk in what I think for my client will be his like late 70s, early 80s. Many things changed, and the General Assembly decided to have a parole system so that these same considerations that a trial court must assess when imposing consecutive sentences, they must also be assessed in the parole process. And since that's duplicative, it's not necessary. It's just not necessary to stack sentences in these ways. The state is arguing for a softer version of the word necessity. They're arguing for a version that applies even if there's a life tail. We've been accused of having policy arguments. I'm sure the court sees arguments across the bar about policy arguments all the time. It's going to come up in any statutory case. I will say that my whole argument is about the word necessity. It's a policy decision of the General Assembly to make that decision. I'm not arguing any policy. I'm relying on their policy. If the word necessary is construed more softly, I guess, in a way where we just sort of say, well, the judge is in the best position to figure out what was necessary in this case, and maybe there was something there about the parole process that the judge wasn't comfortable with. So maybe we can allow the judge to say it's necessary here, just defer to that finding, and then maybe the parole board gets to do its thing if somebody survives that long to get there. That is a policy argument. If this court issues that decision, that would be reasonable to attack on a policy basis, because the General Assembly said necessary, and the definitions in the dictionary define what necessary means. And it means required.
Well, it seems to some extent to me that you're arguing a policy argument as well in this case, that in these instances of cases in which there is a life sentence, then in that case, necessary means something different than it does in a case where there is 4 F4s. And in this particular case, you're saying, hey, you can't say it's necessary because gee whiz, he's going to get to parole in 30-some years, so why tack on additional time? It seems like a policy argument to me.
Well, if it's applied broadly to the class of cases, it is a policy decision of the General Assembly. I would agree with that. I don't agree that I'm making a policy argument. I don't know what facts are going to come up in another case. I'm here for my client. In my client's case, there is no dispute about what the sentence will be. There is no reasonable expectation that the parole board will not be called to its task at some point in the future. The question is when. And so, yeah, on these facts, limited to this case, this court can make a decision that's not policy-oriented. This court doesn't need to say that this is applicable in every single case. It may be that the logic that this court uses in interpreting, well, not even interpreting the statute, just applying it as it's written, that by applying it as it's written, maybe that does take these cases off the board for consecutive sentences as an effect of what the law says, but it's not, I'm not making a policy argument that this court should issue a decision now saying that this will never be permissible. I don't know. I don't know what cases could come up. I think a good example is that there are some sentences for some of the sex offenses where parole eligibility happens after 2 years. I don't think I would be making this argument if that had been the sentence in this case. There are some 2-year to life sentences, there's some 10-year to life sentences. I don't know how this is going to be applied later down the road in other cases where there are different facts in the record. I'm not asking this court to say that, that it'll never be the case. I'm pointing to this case, 30 to life, there will be a parole hearing at some point. Pushing that time off is unnecessary because there's no guarantee that anyone will be getting out of prison in this case. It's totally speculative as to what could possibly happen at the parole hearing. And so saying there's no way to find from the facts in this case that that won't be an adequate protection for those same core purposes, protecting the public and guaranteeing that my client has been adequately punished.
Counsel, but at sentencing, isn't there something to be said for what the victims here had to say and what the sentencing, the implications of that and what might be necessary for?
That certainly matters for the factual findings going to consecutive sentences, but there's a different factual finding that had to be made, which is going to proportionality. We are absolutely conceding on the proportionality finding. That's a separate finding. I'm not attacking that finding. I'll defer to the state as to the facts. My client pled guilty in 5 of these cases. He went to trial on the 6th one, and as far as my review showed, there's no way for me to challenge those facts. I'm not here to do that today. I think that your question is the right question. How does this come into play? But there is this totally separate finding that has to be made on proportionality. The state's brief is a proportionality argument. They are saying, look how bad this is, look how much time is deserved. I'll concede on proportionality. I didn't raise an argument along those lines. I'm not asking this court to say anything else.
1 minute left, Counsel.
But is it really just proportionality, or does it go straight to the determinations, the consideration of the factors of necessity?
I don't know how it could go to the factors of necessity in a case where my client is going to be in prison presumptively for life. I think that we also conceded in our brief that there could be different cases where this could come up in a way that is meaningful, that there could be concerns along these lines in a different case. In this case, the proportionality argument, I'm not trying to rebut it at all. I'll give the state that. But necessity is a different finding. How bad it was in the context of necessity, if there's no life tail, probably that does matter. But with a life tail like this, with the life tail that my client's gonna have to serve, I couldn't disagree more that the significance of the offenses can bear on the necessity question.
Thank you.
And actually, the finding is harder than that for us. It's the trial court's supposed to make its decision that the sentence would be not disproportionate, right? I mean, it's in the reverse. It's even harder for us to challenge. So that finding is a robust, important finding in sentencing cases. We're just not challenging it today.
Come here into your vote.
I reserve. Thank you, Your Honor.
Good morning, Your Honors. May it please the court, Lindsay Paprocki on behalf of the state. I'd like to focus first on Fazio's sole assignment of error and how it's stated in his brief. The sole assignment of error is stated that the trial court's finding of necessity under the statute clearly and convincingly lacks support in the record. But his argument does not focus on the trial court's factual findings in the context of the actual record before it at the time of sentencing. Rather, Fazio maintains that the consecutive sentences in this case, where he was sentenced to a sentence of life in prison with only the possibility of parole, are simply unnecessary. Fazio's claim that the imposition of consecutive sentences duplicate the role of the parole board because it has the discretion to determine when he is released, if and when it is satisfied that he has been adequately punished and no longer represents a threat to society, should be rejected. First, a trial court's consecutive sentences findings must be upheld unless those findings are clearly and convincingly not supported by the record. Fazio has posed the question whether a record can support a trial court's findings of necessity under the consecutive sentences statute if the sentence imposed includes a life sentence. The answer to that question is yes. And Fazio has not cited to a single piece of legal authority that supports his specific legal question. position, He has cited to dictionary definitions of what necessity or necessary means, but he has not cited to a single piece of authority to support his position that a life sentence does not support consecutive sentences. Rather, the state has submitted multiple cases in its brief where appellate courts have upheld the imposition of consecutive sentences that have included a life sentence, so long as the court makes the required consecutive sentences findings. We've cited to a case, State v. Friend, which actually had similar factual circumstances as this, where a life sentence was imposed on a defendant who had pled guilty to a sexual assault case, including the rape of a minor, and then he conspired to kill a detective, a prosecutor, and the minor victim in the case. The court upheld the imposition of consecutive sentences in that case involving the imposition of a life sentence. The same reasoning applies here and leads to the same conclusion, despite Fazio's insistence that consecutive sentences were not necessary due to the parole board's ultimate role in his potential release. Again, he's not cited to a single case that this court should extend his position. This court should instead reject his position, as other courts have done summarily. We cited to a case, State v. Lorain in our brief, where the 8th District did just that, finding that the appellant was simply disagreeing with the trial court's findings and further noting its history of upholding consecutive sentences that include a life sentence, as long as the trial court makes the requisite findings in its sentencing and in its entry. As in Shalene, the problem for Fazio is that the trial court made the findings that consecutive sentences that included a life sentences were in fact necessary. And this court must defer to those consecutive findings and uphold them unless they are clearly and convincingly not supported by the record. The state submits that the imposition of consecutive sentences was warranted under any definition of the term necessary, and that the trial court's findings were fully supported by the record in this case. The trial court in sentencing Fazio agreed that this was demonstrated by the state at sentencing. As to the rape case, which went to trial, the state advocated for a sentence in the range of the maximum, which would have been 170 years to life, to include consecutive sentences. For the ongoing sexual abuse Fazio inflicted upon the victim in that case for a period of 10 years, which started when she was just 5. The state cited to Fazio's complete lack of remorse and his lengthy felony criminal record, which dated back to 1999, and his the fact that he was on bail, awaiting a trial on a charge of domestic violence against his then estranged wife while he committed some of the offenses against the minor victim. The trial court then did hear from the minor victim, who described that she was just 5 years old when Fazio began to commit the crimes against her, and described Fazio as a monster, stating that ever since the defendant has been out of my life, I feel like I can finally breathe. I can sleep at night knowing I'm safe. Leading the trial court to the conclusion that consecutive sentences were not only necessary to protect the public, but to punish Fazio. And as to the sentencing of the 5 cases to which Fazio pled, including cases for attempted murder and conspiracy to commit murder, the record demonstrated that Fazio had stalked his estranged wife, brutally stabbed her in front of their children, and further plotted to kill her, all while in jail awaiting sentencing on multiple felony charges. The trial court later heard from the victim in that case, who also described her fear in living in any world where the defendant was free. Fazio's challenge to the imposition of consecutive sentences hinges on his sentence to life in prison, with life in prison and the parole board's ultimate discretion in determining his eligibility for release. But it is no difference than that made and rejected by the defendant in Chalene. While Fazio may disagree with the position that other courts have taken, he cannot escape the record upon which the trial court made its findings, or upon which this court must review those findings. Because the trial court's findings are supported by the record, there was no sentencing error, and we would ask this court to affirm the sentences imposed by the trial court. Thank you.
Whether it is in 2052 or 2070, when defendant Fazio's parole hearing comes up for the first time, everything that my friend across the aisle here just said is going to be told to the parole board. They are going to hear these things. They are going to make a judgment about whether the punishment has been adequate and whether Mr. Fazio is still a danger to the public. I'd ask this court to recognize that that process and this process serve the same purposes, and because of that, whatever the trial court did that we are now reviewing ultimately is unnecessary. Somebody else is going to do it someday. We concede all the facts. I have no argument against the state as to the facts that were just offered to the court. I'm just saying that under this standard of necessity, we are focused on other things in a case with a life tail. The actual record, let's talk about the actual record. There is some debate at the Ohio Supreme Court right now. There's no holding that this court has to follow from the Ohio Supreme Court. I guess reading the tea leaves is hard. I don't envy that job, but revised code for the moment, revised code 2953.08F2 says that the trial record is a part of the actual record that this court has to review. Under Appellate Rule 9, the trial record absolutely includes all the papers, the original papers filed in the case. I'm relying on the sentences, I'm relying on the transcript. There's no doubt in anybody's mind that these were parolable life sentences. That's enough of a fact for this court to get to. I'm not disregarding the factual record, I'm just pointing to other parts of the record that make it very clear that consecutive sentences are unnecessary under the circumstances. This is a case of first impression for the 9th District, as far as I can tell. I don't know that anybody else has made this argument to the 9th District. But we can talk about the case law that the state relied on. Campbell, Blanton, Chalene, Bennett, none of them actually analyzed the word necessity. They sort of rejected these arguments in conclusory fashion, if they even reached them. I mean, Campbell's a good example. It just relied on Peake, the Peake case from the 8th District, where they had just sort of waved the magic wand and blessed this process without really analyzing necessity. The Peake case itself was decided based on the fact that findings had been made. Now that all the trial courts know that the findings have to be made, we're not really seeing those cases come along anymore. The findings are made in consecutive sentencing cases. We're on the next step. We're talking about whether the record supports it. So Friend and Peake don't even get there. And then Campbell, Blanton, Chalene, Bennett don't actually answer the legal question that we've raised and asked this court to answer. So none of those are even persuasive on the question of what necessity means in this context. The court does not need a prior case to rely on to say what the law is. The law exists before courts make decisions about what the law says. The statutes operate before there's a case out there. I don't need a case, I have a statute that says necessary, and we have made it very clear what we think necessary means. Dictionary definitions, define terms, that's how you figure out what people think and understand a statute would mean. These statutes are supposed to be read and understood in the context of regular folks who may be subject to them someday. I think it'd be very hard for people to understand what necessary means if it's some nuanced thing, if it's something other than strictly required, absolutely essential.
Counsel, I'll note your time's up for rebuttal if you briefly continue.
Yes, we'd ask the court to reverse and to actually modify the sentence rather than ordering a new hearing. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. That decision will be mailed to you by the clerk of the court and the date is legal. And the opinions are also set in the Ohio Supreme Court. With that, I'd like to